Counsel.
Good morning, Your Honor. My name is Cecilia Aylesworth, and I'm with the law firm of Aylesworth & Aylesworth, LLP. Our law firm represents Mr. Abreu, the appellant in this case, and the defendant in the trial court. Mr. Abreu...
Would you like to reserve some time for rebuttal?
Yes, Your Honor. I'd like to reserve a minute. Thank you. Your Honor, Mr. Abreu was denied his due process constitutional rights for lack of due process and an opportunity, a real opportunity to be heard. This case would never even been here had there been a continuance on the motion for summary judgment hearing. At the hearing, the day before the hearing, counsel for Mr. Abreu contacted opposing counsel and notified them that they had never received the notice of hearing in the mail, that they had just received a notice of hearing from the tenant, and that they wanted to reset the hearing. They failed to reset the hearing. They said they couldn't do that, despite the fact that many times you've seen in cases they unilaterally canceling summary judgment hearings, and meanwhile everybody's preparing weeks and weeks for a hearing, and then all of a sudden you show up and it's canceled. But the point is that on the day of the hearing, I did come, and I objected for lack of notice of hearing. And the court went into the whole, you notice the transcript of the hearing. The majority of the time is spent between the judge and the counsel for the plaintiff on what the rule is regarding 20 days of service. The court never granted a real evidentiary hearing, despite the fact that I attempted to swear under oath.
Did you file an affidavit with the court?
I did not at the time, Your Honor, despite the fact that you're still required to have an evidentiary hearing. I don't even have that request a hearing pursuant to notice.
Counsel, the question here wasn't whether the notice was sent timely or whether the notice was sent to the proper address. The question was whether a tenant gave the notice to the appropriate person. So the question was really not on the moving party side. The failure was on the defending party side. And, you know, that of course, its understanding was that the trial court has a huge amount of discretion as to how could abuse of discretion is no other reasonable person ever would do what this judge did by saying this is going forward today. That's your burden. That's the burden down there and here.
Well, I objected at the hearing, Your Honor, regarding no notice of hearing. There was no evidentiary hearing.
Well, there was a notice of hearing. It was sent to the proper address. It was served in the amount of time. It's just that your client, something happened so that whoever was at the premises did not get to you. It was a failure on your side of the aisle. So to say that there was no notice is not correct.
All right. Well, in Futurary versus Miller, which is the 3rd UCA 1991 case, World of Wheels in Miami, which is the 3rd UCA 1990 case, there is a presumption of correctness that the notice of hearing was sent. However, it's a rebuttable presumption.
But you didn't file anything to rebut it. You didn't file an affidavit.
Had I was at least attempting to object and
No. Why? I need to understand why you didn't file an affidavit, though.
Because I didn't know I had to file an affidavit. I had attended hearing to object. I figured my attendance. Anyway, even if I hadn't filed, I'm still entitled to an evidentiary hearing.
No, you're not. Not unless there's something raising the issue, such as an affidavit stating why it wasn't received. Was it an incorrect address? Was it sent to the wrong party? Did your secretary drop it behind a desk? Something like that. Then the court is required to have an evidentiary.
And you were the attorney. The person who failed to get the notice to the attorney is the person who needed to file the affidavit saying, this is my address. My tenant received it from Jones. My tenant failed to give it to me in time for me to give it to my attorney. You were not able to give any competent, substantial evidence at this hearing because all you could testify to is my client didn't tell me about this until yesterday, which is no excuse.
And the hearing was not an evidentiary hearing. At that hearing, the court was not going to be taking any sworn testimony at the summary judgment hearing. So it was incumbent upon you to file that affidavit beforehand.
Okay.
But even let's get past that for a minute.
Okay,
That issue. Where is the problem with the summary judgment foreclosure? Let's get to the merits of that.
Because it has to be a harmful error to be reversible.
Before I just jump into that, I just want to make a point that there is case law that talks about where the notice of hearing was docketed on October 13th, 2011. However, it was missing from the file. Then recently, I submitted a certified copy of it with the clerk's stamp, which is a reply brief. And that certified copy shows that service was not on October 12th, as they alleged, which would have been allegedly 20 days without, you don't take into consideration Rule 1.090E, which is the 5 days for mail time.
Counsel, services by mail is when it's put in the mail, and the certificate of service would have been the service date that would have been. So it's not, forget the 5 days by serving by mail. That's how you get to respond to something that's sent to you by mail. You get an additional 5 days.
Well, it was not kind of. If it was on the 12th, it would have been untimely pursuant to 1.510C and 1.090E.
Was the notice of hearing the statutory requirement, or was the filing of the motion for summary judgment the statutory requirement?
Well, Judge Daly's residential foreclosure handbook and administrative memorandum.
There's a rule of civil procedure.
Yeah, the handbook is not binding on anyone.
The rule of civil procedure requires the motion to be filed within a certain number of days. I think it says filed and served. So now we're talking about something else here.
The notice of hearing pursuant to the court's own administrative memorandum says 10-E.
Counsel, what did you not understand about what Judge Fernandez just said? That's just, that's a piece of paper which I issue out of here. The rule of civil procedure requires for when a motion for summary judgment must be filed. That is something different from when the notice of hearing has to be served on you. So now we need to get back to Judge Suarez's question, which is, there are a lot of technical errors. I'm going to translate Judge Suarez, although I should not. There are lots of technical errors which require in every proceeding, even a trial. But if the error is, those technical errors are not reversible, harmful error, then we don't reverse. So what is it here that you would have had to raise at that hearing that you did not get to raise, or that would have made a difference in this case?
All right. The CAC Home Loan Servicing or its predecessor did not have standing at the inception of the lawsuit. The lawsuit was filed on April 7th, and there's an assignment of mortgage that appeared 30 days before the summary judgment hearing. That never appeared in the record prior to that date. It reflects execution of an assignment of mortgage on April 30th. That's 23 days after
Who assigned the mortgage?
MERS assigned the mortgage
and MERS is a servicing agent for who?
On behalf of CWB, Countrywide Bank SSB, which was an inactive defunct company at that time. So, first of all, there's a question of how did MERS have authority to sign on behalf of an inactive defunct company?
So here's the bottom line, counsel. Was the original promissory note mortgage turned over on the day of the summary judgment?
It was filed in circumvention of our rules of pleading.
The question is, Judge Walsh is asking you, was the note and or the note mortgage, the note, the original given to the trial judge at the time of the summary judgment hearing with some sort of an assignment or a blank endorsement of blank or something like that?
The assignment of mortgage, the mortgage and note, the one that they were relying on was the one with the undated blank endorsement.
The blank endorsement. Okay.
The affidavit in support of the motion for summary judgment they make reference to the note with the undated.
If the original of all of those documents were filed with the court, then what is it's done. If the originals are all filed, it's done. It's finished. How is your client harmed?
Because you cannot plead a case
How is your client harmed?
Because they filed a note that was different than the note.
How is your client harmed? It is the original note and mortgage. Your client, there's nothing left.
Okay. The endorsement on the original note is a photocopied or rubber stamp or electronically simulated endorsement. It's not original endorsement, or there's an issue of fact as to that because we were never entitled a chance to raise any defenses to it because it was filed via notice of filing.
What defense can you raise to that when the original documents have now been surrendered and can never be utilized for anything else in the world? They are goners.
Because, Your Honor, just because somebody takes something, steals something, doesn't mean that you have a right to foreclose. If I saw your house and I go, wow, I like her house, and let's say...
Counsel, if, under the law, if someone had stolen those and the originals are now in that court file, your client still has nothing, has no harm, no fear from those documents ever again. They're gone. It's gone. It's over. That mortgage and note and all of that can't be resurrected by anyone against your client.
The only potential harm is that the client would have been required to pay that note twice if whoever is foreclosing doesn't have the original note, and that's not the case here.
Well, we don't know, because there's actually...
You do know because the original note and the original mortgage, no matter even if my grandson scribbled in crayon all over it, were surrendered, knowing it's going to collect on them ever again.
Let me bring a point that's attached as a certified copy to the reply brief. There's an assignment of mortgage post-judgment. This court has held that a mortgage merges into the final judgment. That means the separate document, the mortgage no longer exists. You have a post-judgment...
There was an assignment to nothing.
But
nothing got assigned.
Well,
the mortgage is a goner. It's finished. It's over.
But you have title issues. The point that Judge Fernandez was raising...
Counsel, you're not here.
Potential of another party
Counsel, your client's interest in this property has been foreclosed. Your client has no title arguments to make anymore. It's over. It's not your client's problem anymore.
Your Honor,
you have to demonstrate
I object, Your Honor, because they did not have...
Counsel, you don't get to object here. Counsel, you don't get to object here. You get to argue the law here, and I've let you go way over your time.
Hey, let me ask you one question. I understand your argument. I understand where you're coming from, but don't you have a problem with your argument from the standpoint that in September, an amended motion for summary judgment was filed with copies of this note, and it showed an endorsement. Let me finish. Showed an endorsement, but additionally, you were also put on notice that you could go by and look at the note and mortgage. It was available for examination. This is 2 months before the summary judgment. Doesn't that hurt your argument? Doesn't that hurt your argument?
It was filed after the close of pleading, 8 months after the close of pleading, more than 2 years after the filing of the lawsuit. All of a sudden, miraculously, this undated blank endorsement appeared on the note.
Why does it matter if you have plenty of time to raise your defenses after the motion for summary judgment is filed, and you raised none of them? After the motion was filed, did you file any affidavits? Did you do anything else to oppose the motion?
I have never received the notice of hearing. How could I have...
Not the notice of hearing. You received the motion for summary judgment.
I understand, but if I had known there was going to be a hearing, under the rules of civil procedure, you have up to 5 days of mailing and 2 days of hand delivery to object to your motion for summary judgment. I have a heavy caseload as well, Your Honor. So I do things based on what's priority at that moment. And so if I had known that there was a hearing coming up, then I would have prepared my affidavit in response to it. And I would have defended, and I would have objected, and I would have talked about how what is the electronically simulated endorsement that all of a sudden miraculously appearing months after the start of the lawsuit, in which they did not have standing at the lawsuit pursuant to the
Counsel, the end result would have been exactly the same. The original documents would have been turned over, and it would be over for your client. It's not even, and you will not find a case out of this court, and this argument is made many times, would not result in any different result.
But the original note was to CWB, to Countrywide Bank.
Counsel, your time is over.
Thank you, Your Honor.
Thank you, Counsel.
Thank you, Your Honor.
Morning, Your Honors, and may it please the Court.
Did you kindly notice your motion or file your motion for summary judgment before the hearing?
I did. If I could just introduce myself for the record so we get my name straight. I'm Ron Gachet. I'm the managing litigation partner at Shapiro, Fishman & Gachet. As this Court knows, we handle a high volume of...
Counsel, that's not relevant to you.
Okay. Of course, we filed our notice timely. There is no rule of civil procedure regarding a 20-day advance notice for summary judgment hearing. It's only a reasonable time in advance of the summary judgment. The motion must be filed 20 days before any hearing can be held, but the rule of civil procedure requires only a reasonable notice. We mailed that notice. Even as counsel says, there's a dispute between the 12th and the 13th of October. It's irrelevant. We mailed it on the 13th, as counsel says. That's still 23 or 24 days before the scheduled summary judgment hearing date of November 3rd. So counsel had plenty of advance notice of the summary judgment hearing. Let me address the lack of notice that she said she got, and let me correct something, Judge Wells, just so the record is clear and for candor to the court. The notice goes to everybody on the service list. The notice went to the tenants in possession because they are separate defendants. Counsel was of record. She was supposed to get her own notice at her law office. What she's claiming is she didn't get her notice at her law office. The tenants also got their notice when we mailed all the notices out at the same time. The tenant probably called the borrower, who's his landlord, and said, hey, what's going on? The borrower probably called their lawyer, and that's how
we don't know that. We don't know that.
But the issue is that she's claiming she didn't get her notice. You thought it was the tenant that ran it up to her.
Did your certificate of service show counsel with the correct address?
Correct. So as you know, that's prima facie evidence that, in fact, the mailing was done. But you raised an excellent point about the affidavit, as I was going to mention. She says, I didn't have time to get an affidavit done. In fact, she could have done an affidavit with competent substantial evidence because you were thinking the tenant had to file that affidavit. But in fact, had she done an affidavit the afternoon that she got it, and we can do an affidavit on a legal pad on the way to the courthouse if we really have to, but she could have typed an affidavit in her office saying, I, the lawyer, did not get my service copy. She could have had that notarized. The hearing was until 11:30 the next morning, so she could have even done it the morning of the hearing. She could have walked into the hearing with the affidavit, presented it to the court, and then made record evidence.
Well, it only matters if there's real defenses here.
Correct.
So she says, you know, the person who ended up owning this wasn't the individual, that we hear this all the time, wasn't the people who brought this lawsuit. There's no standing to bring the lawsuit. There's a case that says out there you have to be the owner or holder at the time you bring the lawsuit.
Correct. You're
defense.
correct.
So?
You're referring to McLean. McLean is a recent decision, I believe, out of the 4th GCA. And what McLean says is, if standing is raised as an affirmative defense, then you have to try the issue of whether or not you had standing at the inception of the lawsuit. Let's be clear. This defendant did not raise the affirmative defense of standing. Under Fidel, it is waived if not raised. So the issue of standing we shouldn't even be discussing. But I will address the issue of the promissory note anyway. But understand that this court can deal with this summarily by saying, counsel, you didn't raise standing as an affirmative defense. What are you doing in here now arguing that there was no standing at the inception? It has to be raised so that I can deal with it during the case. And if you don't raise it, I don't have to deal with it. But there was an issue with an endorsement. There was an issue that the note that was filed, that the first note had no endorsement, and the note that we delivered at the time of the hearing had an endorsement. But we plead in our amended complaint. If you take a look in our amended complaint, in paragraph 7, we said that the plaintiff acquired the right to enforce the note, and that we are the party entitled to enforce the note. That is, under 673, as you know, you can either be a holder or you can be a non-holder in possession. If I have a promissory note without an endorsement, but I'm in possession of it, I'm a non-holder in possession. And
Or you can be an owner.
Or you can be an owner. But we get too caught up in owners these days. Holders really are the people who are really prosecuting these lawsuits, these servicers, the people that represent the owners, because if you have a Deutsche Bank trust, or the asset-backed so-and-so, and you have a trustee, you're not having that trustee come in and prosecute that case. You're having a loan servicer who's the holder of the note. But in any event, we have holder or we have non-holder in possession. Under 673.30112, a non-holder in possession has just as much right to enforce as a holder. If you look in my lawsuit, we say we are the owner and holder of the note, or we have the right to enforce under Florida law. That gets us that if I bring you an unendorsed note, I win, and if I bring you an endorsed note, I win. Now, counsel has a problem with that allegation from the outset. She can file a motion to dismiss, or she can file a motion for more definite statement and say, listen, I'm not clear which theory you're traveling under, or she can send some discovery, or she can do something along the line. This defendant did none of that. In fact, this counsel didn't come into the case until March of 11. The complaint was filed in 09, in April. She comes in March of 11. She has 6 months before we file for summary judgment. We file for summary judgment in September of 11. We send out all our paperwork. We even, as you noted, we sent her a copy of the original note. What we do, because Miami-Dade requires, we can't file the original note in advance. Miami-Dade has told us we lose the notes here. Don't send them in advance. Judge Bailey has told us that face to face.
filed on the day of the summary
So you bring it, but you send it in advance a copy of what you're going to bring so that they're on notice. And if you read our notice that we sent, which is in the record at 101, we say, here is a copy of the mortgage and an assignment of mortgage, because she referenced that assignment of mortgage. And we say, please be advised the assignment of mortgage is being filed pursuant to judge, county, and circuit requirements, not for purposes of reliance by the plaintiff. We don't want to file these assignments of mortgage. We know they post-date the complaint. We know they're done for recording purposes to put the world on notice that we have now taken an assignment of mortgage. But for so long, 08, 09, 010, judges in the circuit courts were dismissing cases if it was a post-dated assignment. It wasn't until courts like yours started to figure out that assignments are irrelevant. We have all the cases now that indicate that assignments are irrelevant, but defense lawyers still continue to grab on to post-dated assignments and try to use them as a ground for no standing.
Were the originals turned over?
The originals were turned over on November 3rd.
Possibility at this point that that note and those mortgages can be enforced against her client.
Absolutely not. The original note is a commercial paper. It's been surrendered. It is now in the custody of the court, and I would point out that there were never any defenses that there was payment, that this is a wrongful foreclosure, you got the wrong borrower. There's been no evidence of that. The defense lawyers representing these borrowers, they look for whatever, as you say, technicalities they can find, but again, it has to be harmful, as you said. We don't think any error occurred here. We think the notice went out, was prima facie evidence, she could have filed an affidavit. We have a note, whether endorsed or not. I'm either a non-holder of possession or I'm a holder. We surrendered an original note with an endorsement. Nothing went wrong in this case. The defendant owed the money. Their house has been foreclosed. We would ask you to affirm the trust court.
Thank you, counsel.
Counsel, even though you went over your time, we'll still give you a minute.
There was no note or mortgage, nothing attached to the amended complaint. So let's start there. You look at the record, no note, no mortgage, no time of mortgage.
That would have been the subject of a motion to dismiss made way back then.
Okay. However, when the recent case of Beaumont versus Bank of New York Mellon, 5th District Court of Appeals, February 17, 2012, in that case, it talks about where they raised new evidence after the close of the pleadings. After the close of the pleadings, 8 months after the close of the pleadings, 2 years and 8 months later, after the beginning of the case, all of a sudden you have an endorsement on a note. How can I raise standing if I didn't know of standing or other issues prior to that fact? Here you have someone there by notice of filing. All the banks and lenders are consistently, basically, via notice of filing, doing an ambush on all homeowners for denying them their opportunity to make their defenses. And so I was supposed to raise defenses that I just found out about, despite the fact that they didn't properly plead it. It wasn't even included in their amended complaint. And then even if I had brought an affidavit
that's not so tough. If it's filed, as we all know, then you move the court to permit you to amend your affirmative defenses to address a new claim or a new issue that's been raised. You at least have to ask. Don't you have an obligation to at least ask to amend your affirmative defenses?
At the hearing on the summary judgment?
When you find out that if you think an assignment changes something or that it's changed standing, don't you have an obligation to ask to amend your affirmative defenses?
If they had properly amended their complaint with the notice of filing, properly amending it by notice of hearing and hearing, say, hey, by the way, this is the real note we're relying on.
Okay.
Okay. All right. The other thing is, if I had brought an affidavit to the hearing, I would have been denied under Rule 1.510C because that would have not been a proper affidavit because it would not have been timely. That's what they would have raised.
Thank you, counsel. Thank you both.
Thank you both very much.